Judge, you're host, right?
Yeah, I'm in the hold.
Um,
Is this better?
Oh, good I am.
Well, I just logged off. Now, yeah, now you gotta let me in. Okay. I logged off to see if that has some, I don't know. It's still blank though. You see, it shouldn't be blank like that. You pulled it out, pulled it back in?
Yeah.
I still, he still
But that
can't.
was,
It's only, one attorney on. Can you hear me?
I can hear you.
Yep, he can hear me. I can't hear him. He said log. I did log off. Something. Oh, he logged off and logged back on. Let's see if that was it.
How about now? Can you hear?
here we go. Seemed like something.
Does that work?
Nope, it's still,
Still not? Ooh.
nope. Hi, good morning, Israel. My favorite person in the world. This kid, Kitty, yeah, Judge Giles clerk. So we have an issue with, What'd you say? We have an issue with Zoom. We can't hear, nobody on Zoom. Right, like the screen is black. Huh? Well, the judge is logged on, I'm logged on. He's host, I'm co-host. It's on? No, it's on because you know it has the little square where you can see the courtroom, that's on. But the rest is all black. It's green. Everything's green. 233. Yes. Yeah. Yeah, because I have an attorney that's on and he can't. No, 230. Yeah. Yeah, but this just Giles. Oh. Oh. Okay. Oh, there, okay, hold on. Let you in?
I think he had the glasses.
Did that
All right,
work?
yeah. I can see him, okay.
Short, brown skin? Yeah.
Israel,
He passed.
yes. What'd you do? Oh. Oh,
Sound?
okay, all right, thank you. All right, all right. Yep. You can hear me, right?
Clear as day.
All right, cool. And we can hear you. What case are you on, Counselor?
Mr. Nabil Odifa, and we're requesting an exam.
We don't have that on the docket.
Don't have it on the docket.
Uh-uh.
That's not good.
You got a case number? You want me to look it up?
Yeah, I don't have a case number, but it's, last name is Odefa. First name is Nabil, and that's weird because it came over as, all right, well, it happens.
Yeah. May have one, it may be one they reassigned, or I don't know. They put the
It could
wrong
be,
judge
just-
on.
It said the Honorable Giles at arraignment.
Or it could be, is it a CCW charge?
It is, that's why I thought it was strange.
Oh, it might be Judge Robbins.
It could be true.
Yeah, you got the case number? You want me to look it up, or?
Yeah, could you please, because 36 District Court's Register of Actions is down.
Okay. You say you don't have, the case number?
I do not, I'm sorry.
All right, let me, all right, what was the last name again?
Odefa,
First name?
Nabil.
I can try this one with the last name. That's not a common last name. 2, 3, 4, 5, 6, 8. Yes, it is assigned to Judge Giles, but is a probable cause in front of Judge Robbins.
Thank you very much, I appreciate it. Have a great day.
All right, you too. Thank you.
Bye-bye.
Well, at least we got the,
What was wrong with it?
he said he just logged off. I don't know what he did.
No, talking about you go, so,
Yeah, I called Israel.
so what did he say?
He went on there and did something.
Nice.
Let me admit this. Good morning, sir.
Good morning.
All right, you're in the wrong courtroom.
What was
You need to
that?
log on to courtroom 440. Your
How do I-
attorney was just on. I sent him to 440. You should be at 440.
Do you have the Zoom for that or no?
That's Judge Robbins. Zoom number 3, that's Zoom is thing, 360. What is it?
360.
440. 440.
40
Perfect. Thank you. Thank you, guys.
Welcome.
He said he may have to come down. Oh, this.
Yeah, they got two prisoners. Yes, courtroom 233. Jay Sean Rogers.
Okay, what's up with this Herwig? Herwig.
No Rogers. Okay. Let me check that out.
Rogers.
Shante.
Shante Dawson.
Yeah,
That's who's the judge.
yeah. I thought we had, Roger Sean, Jay Sean Rogers. Check it out. Sure. Figure that out.
Oh, I got Philip.
Okay.
86.
All right, we just got one, president. Shante.
Who was it?
Shante Dawson.
All right. Down to jail early. Is this not happening?
It's all cute people give you cute money, so. It's called cute.
Good morning, Madam Clerk.
Good morning.
Good morning,
Here we.
Herwig.
Yes, we're waiting on her attorney. Let me call the attorney now.
How come nobody can pronounce my name? It's Herwig. It's easy.
Herwig?
Yeah.
You have a moment this morning, Sharon Collins. She's in, okay, good, because she's on, that's on Zoom, she's in that coming down. 233. She's coming or logging out? Oh, okay. Okay, all right. Well, you're driving, so. Okay, all right. All right. He's on his way here, he's driving, the attorney. Okay, okay, okay. I'm trying to see what happened, what happened on February 22nd? Should have asked. Oh, just agreed, just adjourned. That's the one just agreed, just adjourned. This one. I don't see no report in here, Judge. No, just agreed on February 22nd, she just adjourned it.
Got no report then,
Yeah.
February, you call,
It's a review, she was already found incompetent,
oh, okay. So, yeah,
a review report.
CFP is supposed to give reports. You recall, see if they got anything? If they wanna get show called.
Good morning, Lisa. How are you? Good. This is your kitty. I'm looking for Shannon Hurley. She was isn't complete. Yes. 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 He does after that. He's not. Vacation. Oh. Really? So he's trying to do is triangulate. Yes. So that he can have an accurate presentation. It's not just everybody. Thank you. Appreciate you. All right, thank you. All right. She's not scheduled for review until May 22nd.
Supposed to do reviews every 90 days.
No, backlog.
Huh?
They're backlog, they only have one person do it.
Huh? Only got one person doing
Just a random
it.
time.
Yeah, what day?
She's scheduled for May 22nd. That's Monday.
Yeah, so she's not increasing.
Right.
Right. When was she filing?
January 26th.
I've never seen. I think it's this guy. That one, this guy. And it's not a- Yeah, it's not. What's gonna be searching?
He said it was coming out and then he lost. Oh, we ready. You ready, counselor?
Yes, I am. Thank you.
The 36th District Court, City of Detroit, State of Michigan, is now in session with your Honorable Ronald Giles presiding. You may be seated.
Morning, Judge.
Calling case number 2259829, the people of the state of Michigan versus Shannon Herwig. Defendant is charged with count 1, assault with intent to do great bodily harm, less than murder or by strangulation. Count 2, assault with a dangerous weapon, felonious assault. This matter is scheduled for a review hearing.
Good morning, Your Honor. Ed Book appearing on behalf of the people, P 86266.
Good morning, Your Honor. Jabari Prempeh, P 81745, on behalf of Ms. Shannon Herwig, who is present via Zoom. Ms. Herwig, would you please state your name for the record?
Shannon Herwig. Shannon Herwig.
We have you, man. Thank you. All right, we contacted the Center for Forensic Psychiatry. They only have one person doing these reviews and they're behind. So Ms. Herwig is not scheduled for her review until 5/22. So we're gonna have to put this matter over. We're gonna put it over till June 16th at 8:30.
All right, let me check my schedule real quick, Your Honor. June 16th. That should be fine.
Can I please speak?
Ma'am, you have to talk to your attorney about that.
And I will contact Ms. Herwig off the record. I will contact her where she is in the jail.
All right.
Thank you, Your Honor. Have a great day.
Thank you.
So,
Ms. Herwig, we can't do anything till we get a report back. And hopefully soon they will get you into treatment.
I don't need treatment. I did nothing wrong and I'm not incompetent. I'm fully competent at what I do.
Well, you've already been found incompetent, so I need a psychiatrist to say that you are competent. So we have to get you in treatment.
I don't need treatment. I need
Ma'am,
to go.
ma'am.
I do nothing wrong. I defend myself.
That's the end of the hearing. The next date is gonna be June 16th. What did I say, June 16th?
Yes.
June 16th. At 8:30.
Attorney Noah Goldman. I don't know what that is. Courtroom 233, Judge Giles, courtroom. Can you help me? Yes. Yes, I mean, she didn't. The judge adjourned to June 16th. June 16th, right, Judge? Yeah.
8:30.
June 16th, at 8:30, yeah. Yeah, I did, well, we were done with her, she walked away, so yeah, that too, she was probably mad at that too. No, but we're done. You too, thank you. All right. Share. All right, let me see if I can.
How you doing this morning, Judge?
Okay, how you doing? You know, Mr. Oshek, then, client?
They're not here yet.
Oh, this.
Tonight, they're. So, Wayne's,
14, 6. It wasn't just a trip.
that was awesome.
Yes. Yeah. They deserve where they're at.
Hey,
Guess Attorney Goldman didn't want to talk. Huh?
Hey, Judge. I have a question about like search warrants, specifically ones that are asking to search for identification records. Obviously, search warrants have to be particularized as to like where they're searching, what they're looking for. With telecommunication, it's like what I've seen, the ones that are sent to me, they usually ask for like 3 geographic points and they usually don't know. Is it too broad to say like we're just looking for anything we can pick up in this
Oh, he was a
small
video
triangulated
bomber.
area? That's not too bad? Okay.
Search warrant based on something.
Hard.
You know, I mean, as long as they got some. So that means some kind of. Why they're looking.
But just to say like, whoever we can see in this area, that's what we're looking for. That's right. I was like, so he has,
Whoever we can see.
they're looking for a suspect in a specific triangulated area. My area is that was like, well, there could be like dozens of people in that triangulated area. Exactly, so I'm wondering if it's that too. Yeah, that's what I thought too. Okay, that's terrible, but I like red. Well, make sure, I'm like, I don't know, I think it's gonna be white.
Normally, they would say something like. Information, even if it's from someone else. How does the person. This area, seen in this area, the car that the person drives. Like wind reader or whatever, you know, something.
Judge McConville was,
Yeah, so they did have
reason
that.
to look.
Yeah, they had surveillance video, which you saw this guy. They don't know who he
See,
is. See the person
this
out
blind.
there. And so now they're looking for him that specific. And I told them, like, what is two projects? Okay.
I gotta narrow it down. That's 1,000 people.
Yeah.
Yeah.
Okay. Thanks, Judge.
Judge, so this
We scored over that one.
You ready, Council? Calling case number 2356679, the people of the state of Michigan versus Jay Sean Rogers. Defendant is charged with count 1, assault with a dangerous weapon, felonious assault, count 2, weapons felony firearm. This matter is scheduled for examination.
Good morning, Your Honor. Ed Booklet appearing on behalf of the people, P 86266.
Good morning, Judge. Neighborhood Defense Service of Leno, P 83424, appearing on behalf of Mr. Rogers, who is present in the courtroom. Mr. Rogers, please state your name.
Thank you. Steve?
I know, Your Honor, today's the day and time set for examination. Both Nicholas Reed and Tyrone Talafer were subpoenaed. Both myself and the victim advocate in this case attempted to reach them this morning. They would not answer either of our phone calls, Your Honor, so we are unable to pursue that.
Judge, the time to dismiss without prejudice.
Matters dismissed.
Thank you, Judge.
Go ahead, outside the attorney, break. Judge, Mr. Rogers does have a GPS teller on. Do we need a order to remove the GPS teller?
No, you can take the dismissal along with the register of action and
We'll remove it. Thank you, Judge.
go on.
Mr. Simon. That's 9:45.
Nine.
Yeah.
Still waiting on. Oh, yeah.
Oh, I think. That's a good question.
Domestic violence, are considered domestic violence.
Oh,
That's the
right.
one we- You better put it down.
That's
That's why he's a judge.
right. Right, it'll take 5 of us to figure it out. He already knows.
Top of your-
Well, you didn't know.
Well, it'll take 5,
Well, how many does it
because
take?
I never, I just about saw it today.
Mhm, that's a 2 defendants,
Yeah.
Beasley and Ruff. Chop shops.
Sounds like.
Chop shop. I wanna see Jennifer Lopez new movie.
What is it about?
It's called Mother.
Oh, that's all.
You seen it, Dad? Was it good?
Yeah, it's pretty good.
Was it like a chick flick or more of an action?
More action.
Is it? Because my husband don't wanna watch it.
Oh, it's not a chick flick at all. She's not
So she does, pretty good as a,
as an action.
yeah,
Yeah, well, she's more believable. You know,
Yeah.
because she's athletic. Her build is athletic. build.
yeah.
You get someone like Angela Jolie, who's a little skinny thing, throwing around 250-pound men, it's like, yeah,
Mhm.
right.
Yeah, I guess she had to train for that too. She did a lot of training.
Well, you can't get that person small, sometimes you just quit her. You can't do something. You have to
Some
really-
things, but did you see Salt?
How you doing?
Did you see Salt? That was totally unbelievable.
Yeah.
You saw
yeah.
some?
Mhm. Yeah, I don't think I really care for Angela.
I saw Mr. and Mrs. Smith.
Yeah, I seen that too.
You know, when they come on, they're like, Angela, that she gets hit by a big guy. And act like it.
Oh, no, that-
Didn't phase her, like,
Hey, that's not true.
Right, right.
If she doesn't go down, her face will swell up.
oh, also another one, have you seen Hypnotic?
Hypnotic.
That's a movie.
Mm-mm.
I saw the other day.
Who's
I
in
like
that?
it.
It's a new movie?
Yes, a new movie. What's the guy's name? Who plays Batman?
Oh,
Ben Affleck?
Yeah, Ben Affleck.
Oh, Ben
Yeah,
Affleck.
he's in it.
Oh, it's called Hypnotic.
Mhm.
Oh,
It was pretty good.
Mhm. I like it.
He's not a big guy.
so what type of movie? Is it an action movie? What type of movie is it? It should be not Hypnotic, not
It's an
that.
action suspense type.
The Japanese suspense.
It's, But the basic premise is that hypnotic are, just like they say, the folks that have telekinetic ability or telepathy. Well, telepathy reads your mind. Hypnotic can move things with your mind. But a hypnotic person can change your perception of reality.
With sweet.
Oh,
So
wow.
to make you think that things are different than what they are.
Oh, okay. All right.
You don't need
That
that.
might be kind of.
You don't need that because you already got it.
Whatever.
So when I went to see the movie afterward, every time she would say something, especially if I thought she was wrong, I thought, no. And I tell her, yeah, I changed it all for you.
See, I don't think I've seen previews enough for that.
We didn't see.
No, I haven't.
seen any preview.
Oh, wow.
Maybe because it might give way too much, because like you were trying not to say too much. I know, but no, I haven't seen it.
Yeah, I've seen previews of Mother, but not.
Like, did Mother, I didn't see Reeves.
My mother's on Netflix.
Yeah.
It's on Netflix?
It's on Netflix.
Yeah.
Oh, I see that.
Yeah, it's a Netflix movie.
And Hypnotic, is that?
No,
Netflix?
if you go see it, just like a Marvel movie,
Mm-hmm.
stay afterwards. There's another part of the
For what, Hypnotic?
Yeah.
Oh,
Are
really?
you serious?
Yeah.
Oh.
Folks are following in Marvel footsteps that started to do that.
Right, so you gotta sit there and wait.
He's more popular.
Right. Make sure you say some more about that. Okay.
We start, I was waiting for other folks to leave the theater. Because I'm kind of slow. And when I started going down the stairs, when it came back, oh.
Sit back down.
Sit back down. I was like,
Yeah. Movie I wanted to see the fight. I wanted to see the last movie with actually man. Wait.
Oh,
still
John.
there.
Did you see it?
It's at MJR.
It's 4, right? No.
No, it's 4. Yeah, I haven't seen the first one.
Oh, you did? Oh, the first one was
I'm gonna
awesome.
watch it.
The first one was very good.
Yeah, I like all John movies.
Yeah, I did too. Cool. I'll see that.
I'm shocked.
Jason Momoa is going to be in the next Fast.
Very
Fast
good.
Furious.
Yeah.
Oh, really?
I can't believe they got like this 10 or something. They had some.
Yeah, I think this is 10.
Yeah, this is 10.
Yeah, this is 10.
Fast 10.
That's your work. Yeah, I thought so.
Hey, watch it. I stopped watching after Paul Walker.
I just want to marry Paul Walker. That's too bad. I had to Paul Walker.
I know.
Yeah, you doing better now? Oh, yeah, I'm fine. Yeah, we'll recover. I think so.
Oh, are we ready?
Just one moment, let me just make sure.
Okay.
Paul Victor, he said he was here.
Yeah. She's gonna sit right there. You gotta see right. So you choose. Just in case, I just.
All right, call it.
Stand up, please.
Parties ready on Ashante Dawson. Calling case number 23-56698. The people of the state of Michigan versus Ashante Dawson. Defendant is charged with count 1, assault with intent to do great bodily harm, less than murder or by strangulation. Count 2, assault with a dangerous weapon, felonious assault. Count 3, count 4, weapons, felony, firearm. Count 5, domestic violence. This matter is scheduled for examination.
Good morning, Your Honor. Adam Bookler appearing on behalf of the people, P86266.
Good morning, Your Honor. Jonathan Simon, P 35596, on behalf of Ms. Dawson.
Ready to proceed?
Judge, you ready?
You have to speak a little louder. Thank you.
Yes, Judge, we're ready to proceed. Just two preliminary matters. First of which, just the mutual order of sequestration of all witnesses. The exceptional officer in charge who should be coming in here shortly. He will not be testifying.
Any objection? All right, you know, witnesses testifying today at trial or anytime in the courtroom, YouTube and Zoom, or we deny that future testimony. Give exception to the officer in charge.
Thank you, Judge. And I told Mr. Simon that the proof show that people would intend to add a charge of assault with intent to murder.
So I acknowledge he did tell me that. I don't think it's going to be justified, but we'll see where the proof's going.
All right, yeah, you're on notice.
Thank you, Judge. The people would call their first witness, Mr. Anthony Rodman.
Okay. Raise your hand. Swear or affirm to tell the truth, the whole truth, and nothing but the truth.
Yes.
Close the door for you. Couple of things, Mr. Rodman, first, I don't do sweats in my courtroom, and I certainly do not do shorts.
I do apologize.
I appreciate that. I prefer to have your respect. Come to court, you wear, you dress for court, all right?
Yes.
All right, thank you. All right, you're gonna receive, you're gonna be asked a series of questions. First by the prosecutor, and the defense attorney will probably ask you some questions, and I may or may not ask you questions. You have to answer all your questions out loud verbally using words. You just can't shake your head and say, uh-huh. You have to say yes, no, whatever the answer is. Also, I need you to listen to the question, just answer that question and stop. If it's a yes or no type question, just say yes or no and stop. If they want additional information, they'll just ask you another question, all right?
Yes.
Also, we all have a tendency when we've been through something traumatic, we tend to ramble when we talk about it. We'll say this happened, and this happened, and this happened, and this happened. If you do that, I'm gonna miss something. If I miss something, I might not make the right decision, okay? That's why we proceed by one question, One answer at a time, that way I can understand. All right?
Yes.
Thank you. May proceed.
Thank you, Judge. Sir, could you please state your name for the record one more time?
Anthony Rodman.
Mr. Ryman, I'm gonna direct your attention right back to April 30th of 2023. You're at the location of 18951 Shiawassee Street,
Yes.
is that in the city of Detroit, County of Wayne?
Yes.
What is at that location?
What is it?
Yes.
It's a house.
Is it like a single family residence?
It's a bigger house, 2 floors basically.
Um, Who lives at this house?
Me, my girlfriend, and at the point, it's Ashanti.
So, I want to direct your attention specifically to just before 2 PM on that date at that location. Did anything happen that might bring us into court here today?
Yes.
What happened? Briefly.
Basically,
Question and answer, not narrative, please.
Understood.
basically, we walked into the house.
1 second.
Yeah, Judge, I would ask if instead of a narrative, we could have a question and answer form.
That's what I just directed. See, my question and answer, not narrative. Of course.
So, you were present at that location, right?
Yes.
You just said? Okay. Was anybody else there with you that day?
Yes, Miss Lori Jones was there as well with me,
Okay. Who's Miss Lori Jones?
my girlfriend.
So, just before 2 PM on that day, what if anything happens?
Basically, we walked into the household. When we walked in, I went home to get ready for work. Miss Ashanti was upstairs, basically.
Judge, it sounds like a narrative to me.
It is a narrative. If you have to open any question, what happened, you're gonna get, don't tell me what you're gonna get.
I understand.
So I need you to break it down, please.
So you said you walked into the location with your girlfriend, correct?
Correct.
Okay. And I heard you say Miss Ashanti was upstairs.
Yes.
So when you walk into the location, do you ever make contact with Miss Ashanti?
I did not know.
Okay. So what do you do then after you walk inside?
I went towards upstairs to go get ready for work.
Okay. So what happens when you make it upstairs?
I heard the arguing downstairs.
Okay. Did you recognize the voices that were arguing?
I know the voices, I know who was downstairs.
Okay. So what do you do when you hear this argument?
I came downstairs instead of getting my uniform on.
So what if anything, do you observe when you get downstairs?
Well, the arguing that I heard was
No,
when,
you can't say what you heard.
Yeah.
You know, listen to the question and answer the question you're asked, please. It'll go much faster and much smoother.
all right, one more time for me, I'm sorry.
So I'm asking, what did you observe with your eyes? What did you see?
When I came down the stairs, you can see the gun in her, it would be her right hand on her side,
So let's stop right there. Who is holding the gun?
Miss Ashanti.
Do you see that person that was holding the gun in the courtroom here today?
See the face?
You can stand up if you need to.
Yes.
Could you please point to the person that was holding the gun and identify them by an article of clothing?
The green over there sitting down.
Thank you. Your Honor, may the record reflect the witness that identified the defendant, Ms. Ashanti Dawson. Thank you. So you said you see Ms. Dawson holding a gun.
Yes,
Where is she standing when she's holding this gun?
in the living room,
How far away from her are you at this point?
probably 10, 15 feet of that.
And you said that you came downstairs, so are you at the base of the stairs at this
Yes.
point? Okay. What kind of gun is Ms. Dawson holding?
It's like a 6-shot revolver type of gun. It's an older, I really didn't see it, to actually be able to tell you what it is.
Okay. So you see her, what hand is she holding this gun
And to be her right,
in? And which direction is she facing? Is she facing you? Is she facing somewhere else?
once she seen me at the bottom, she faced me.
Objection to what my client might have seen. I think it's speculation at best.
You can't testify what's in, what she sees. He testify what he saw.
Understood. So we can move on from this line of questioning. So you get down to the base of the stairs, you see Ms. Dawson holding a gun. What do you do at this point?
I didn't, once I reached the bottom of the stairs and I seen it, I didn't want to proceed, with anything. So I stood at the bottom of the stairs to just try to listen to what was going on.
Okay. So without telling me what anybody said, what if anything happens next?
The gun was pointed at me, but it was not fired. in the house.
So this is inside the house, the gun is pointed at you?
Yes,
Okay. How far away are you when the gun is pointed at you?
still about the same 10 to 15 feet.
So what do you do when the gun is pointed at you?
We ended up going outside.
Hold on, so what,
Me and Lori.
you and Lori both went outside? Okay. What if anything happened when you stepped outside?
You know what I'm saying? We walked outside, you know, a couple minutes. We were sitting outside, you know what I'm saying, in the yard, trying to, you know, get her to drop the gun. And she came outside. The first shot was fired directly into the air.
So let me stop you right there. Before that first shot is fired, at any point, does Ms. Dawson say anything to you when she has the gun in her hand?
She stayed in the house
She stayed
until she came out and fired the first one.
Did she say anything before then?
No,
So she comes outside, where's she standing when she fires this shot?
directly on the porch, in between the house and the porch. But you can see it
And where are you? Are you closer to the house than she is, or are you farther from the house?
on the sidewalk.
Okay,
So it's still about 15, 20 feet now.
okay. And so what does she do with the gun?
Directly in the air and fires it.
How many times does she fire?
Once in the air.
So what's going through your head when she fires that shot?
Objection, relevance.
Element of dangerous weapon.
No, that would be the intent of the defendant, not the plaintiff.
No, goes to what his mind is. Oh, no, your objection is over.
Thank you, sir. So I'll ask the question again. What's going through your head when that shot is fired?
You know, a little scared. You know what I'm saying, especially not just for me, but especially for my girlfriend as well.
Does Ms. Dawson say anything after she fires that shot in the air?
No.
So
Like I said, I was at a distance. I did not hear anything if it was said.
So what if anything happens after the shot is fired?
I think what I had explained is I was not really bothered and I showed that, you know what I'm saying, when she fired it off into the air. That's when the gun was pointed at me and fired again.
How many times was it fired? When it was
Twice, directly at me.
How far away were you when those two shots were fired?
About 15, 20 feet still.
Were you impacted by any bullets that came out of that gun?
I was not.
When Ms. Dawson fired those two rounds, what hand was she holding the pistol in?
Right.
Did she have both hands on that gun? What's going through your mind when the two shots are fired directly at you?
I was startled. You know what I'm saying? I'm a little scared, you know, but not, I was more worried about the protection of my girlfriend at that point.
Was your girlfriend struck by any gunfire?
No.
So what, if anything, do you do next?
Me and her went down the street.
Objection, I want actually clarification. I don't know what the word means.
Yes, so
We walked down the street basically to get away from it, you know, past the trees and everything that are next to our house.
when you say we, are you talking
Me and
about?
Lori.
So throughout this whole encounter, are you and Lori together at every step?
Yes, from the moment we walked in until the moment the police arrived.
So you said you walked down a couple of streets. Do you
They
observe?
walk down the street.
Yes.
Literally probably 30 feet past all the scenery, like the bushes that we have next to our house to get out of sight.
Do you observe Miss Dawson doing anything as you're walking away?
Just sat on the porch.
No further questions, Your Honor. Thank you.
Judge. Rob,
Yes,
this woman that you've identified here in court, Ms. Dawson, okay, do you have a romantic relationship?
no,
Do you have any children in common with her?
no,
Now, she lives at that address?
yes,
This woman Lori lives at that address?
yes,
Is there a third woman also residing at that address?
yes,
And they are tenants of that property, as
That is
far as you
correct.
know?
that is correct.
Now, you're dating this woman named Lori, right?
Correct.
And what is Lori's last name?
Jones,
Jones?
Jones,
What's the name of the third woman?
Danielle, I don't know the last name.
Okay. And how long have you been dating Lori Jones?
What's the relevance?
How long do you know has Lori Jones been staying at that Shiawassee address?
We've been at the house about 2 months.
I asked you about Lori Jones.
2 months.
Okay. And she has a tenancy at that property, correct?
Correct.
You're not a tenant at that property, are you?
Yes, I am.
Are you, remember, are you a leaseholder?
Yes, I am.
When did you become a leaseholder?
Judge, I object to
Irrelevant.
relevance, yes.
What's the relevance?
Well, I think that there is a charge of domestic violence, and I'm trying to determine whether there's a domestic relationship.
Well, the violence is a misdemeanor, and I'm not concerned about it. This is a probable cause here. I'm only concerned about the felony.
Okay, so you're named on the lease agreement,
Yes,
and when did you become a leaseholder?
2 weeks ago.
2 weeks ago. What date was that?
Judge, I'm gonna object to relevance.
What's the relevance is line of question?
This is alleged to have occurred April 30th, that would be more than 2 weeks ago.
Okay, so
So I'm just simply attempting to establish that he was not a leaseholder at the time.
what difference does that make? It's not a defense to the act that your client is charged with. So what difference does it make? How is it relevant?
Well, may I ask just one question?
I don't know. I have to ask the question and we'll see if
Did
there's
you
a difference.
become a leaseholder before or after April 30th?
Object to relevance, Judge.
How is it relevant?
I'll move on.
Judge, I would ask that Mr. Robbins' answers to those questions be stricken from the record.
Well, I mean, no, at this point, at the point that, I allowed it initially to see if it was going anywhere. That the court could find to see if it was relevant. Court found, I didn't see it going anywhere that was relevant, and I stopped it at that point. So what happened before, there was no objection, I'm leaving. From the point I stopped it, that's all stricken, it's not,
Thank you.
I don't know,
Right.
sustain the objection.
When you first entered the house and you went upstairs to change clothes to go to work, right?
Correct.
Did you see Miss Dawson at that time?
In the living room.
Did you see her gun?
It was not pulled until I went upstairs.
The answer to the question was, did you see her?
No.
Okay. You go upstairs, correct?
Correct.
And does that put you out of the line of vision between Miss Dawson and Miss Jones?
Correct.
Okay, but you hear things, correct?
Correct.
And that causes you to come back downstairs.
Correct.
And at that point, you see a gun?
That is correct.
Okay. Now, and there were no shots fired in the house, right?
Correct.
There were, your testimony is the shots were fired as Miss Jones, I'm sorry, you and Miss Jones were on the sidewalk and Miss Dawson was on the porch.
Correct.
And that you heard no words at that point,
That
correct?
is correct.
Okay. And the first shot was fired in the air,
Correct.
and the two other shots were fired in your direction,
Correct.
but you were not struck, correct? Miss Jones was not struck,
That is correct.
okay? And there were no other words uttered at that time, as those other two shots were fired, correct?
Correct.
Okay, thank you. Did you say anything to Miss Jones? I'm sorry, Miss Dawson.
No.
Thank you.
I have no further questions for this witness, Your Honor. Thank you.
All right, thank you, sir. You can step down.
If people have no further witnesses, I would rest. Your Honor.
Is there any witnesses?
No witnesses, Your Honor.
All right, is an argument?
Of course, Your Honor, the people in motion for bind over on all counts, and I'll just go through each count individually. As it pertains to count one, assault with intent to do great bodily harm, less than murder, or by strangulation, I believe the people have met their burden in this case, Your Honor. Mr. Rahman testified that he was not hit, nor was his girlfriend, Miss Lori Jones, hit. Thankfully, neither were hit, Your Honor, but actual injury is not necessary to prove assault with intent to do great bodily harm, less than murder. quoting the criminal jury instruction 17.7, assault with intent to do great bodily harm less than murder. The people first need to prove that the defendant tried to physically injure another person. I would argue that we've proven that here, Your Honor. A gun was pointed in the direction of Mr. Rahman and the trigger was pulled 2 times. Second, that at the time of the assault, the defendant had the ability to cause an injury, or at least believe that he or she had the ability. I believe we've met that burden here too, Your Honor. A gun that's loaded and then bullets that are sent through the air would indicate that the defendant in this case had the ability to harm Mr. Rodman or anybody else that was in the air. And third, the defendant intended to cause great bodily harm. Actual injury is not necessary, but if there was an injury, the jury may consider it as evidence in deciding whether the defendant intended to cause great bodily harm. So no actual injury is necessary here, Your Honor. But I believe that the act of aiming a gun at somebody and pulling the trigger twice, not just once, but twice, definitely shows an intent to at least cause great bodily harm. As it pertains to the felonious assault count too, Your Honor, I believe the record has satisfied that, and both felony firearms that would attach that. For the assault with intent to murder that the people intended to cause, I would bring up the same argument as the assault with intent to do great bodily harm. The trigger wasn't just pulled once, it was pulled twice at relatively close range of about 15 to 20 feet. I don't believe that just because Mr. Rodman or Miss Lori were not hit that, well, those 2 charges magically disappear. I believe that in this case, the aiming of the gun and pulling the trigger not once but twice clearly shows an intent to do great bodily harm, if not intent to murder, Your Honor. So I believe the people have met their burden in this case, but again, I ask you for a bind over on all counts. Thank you.
As a clarification, all counts, does that mean all charge counts, or does that also mean?
That also means the added count, which would be count 6 of assault with intent to murder.
Okay, with that in mind, Your Honor, I would object. I think that the evidence has not shown the intent to murder, or certainly not intent to murder, and not even the intent to do great bodily harm. I agree with counsel that injury is not an element, but there must be something to show intent to do great bodily harm. It's a specific intent crime, just as intent to murder is. And you must show something to indicate that at the time of the discharge of the firearm, there was that specific intent, the intent to cause great bodily harm, the intent to murder. All we have is the discharge of a weapon. There's no words, there is nothing to indicate that there was anything more than intent to cause apprehension of an immediate battery, which is the felonious assault. And as much as I would like to argue that there's no evidence of a domestic relationship, I understand that it's a misdemeanor and it's not before the court at a preliminary examination. However, given my argument with respect to intent, I would ask the court to dismiss count 1, which is assault with intent to do great bodily harm, count 3, which is the felony firearm associated with the count of assault with intent to do great bodily harm, and the proposed count 6, which would be the assault with intent to murder. I haven't heard a motion to add a felony firearm as to that. But Your Honor, I would submit that as to counts 2 and 4, felonious assault and felony firearm associated with the felonious assault, that would be a question of fact.
Yeah, rebut briefly, Your Honor.
Sure.
As it pertains to intent, Your Honor, if we could only charge specific intent crimes based off of what a defendant said, we would never have, or we would rarely have, specific intent crimes like great bodily harm, intent to murder. Intent in this case can be inferred by the actions of Ms. Dawson. I believe that the people have met their burden based off of the actions of Ms. Dawson, pointing the gun at the victim and pulling the trigger not once but twice. Your Honor. So I would again ask for a vote. Thank you.
The court having heard testimony and arguments, answers as follows. Heard from Mr. Anthony Rodman that on April 30th, 2023, approximately 2:00 p.m. in the area of 18951 Shiawassee, he was at his home. His girlfriend was there, and who also resided in that home, and the defendant, Ms. Dawson, was there, who also resided in that home. He had walked in the house with his girlfriend. He went upstairs to change clothes for work. He heard some voices arguing downstairs. He came down, saw the defendant holding a gun at her right side, in her right hand. and they were in the living room. He was approximately 10 to 15 feet away. She had what appeared to be a 6-foot revolver. He stood at the bottom of the stairs. She then pointed the gun at him. They said he was scared that he and the girlfriend then left to go out, went outside. The defendant came outside, fired one shot in the air. They were again approximately 10 to 15 feet away. The gun was pointed in his direction. It was fired twice. Was startled, a little scared. He and Lori then walked down the street. He said approximately 30 feet, I guess, past some bushes, etc., where she wouldn't be able to see them. And the defendant then sat on the porch. Court finds that, I'm going to bind over on the existing count. I'm not binding over on assault with intent to murder. I don't have anything on this record that would give an intent to murder. The intent to do great bodily harm, is questionable or circumstantial. Let's put it that way. It's circumstantial. But she did fire a total of 3 times, 1 in the air and then 2 in the direction of the complainant, of the victim in this case. With that, I think that's enough for probable cause to leave it up to a jury to decide if it meets that burden. So the court finds that the felonies enumerated. And as to the because there was an argument directly on the domestic violence. I heard no evidence on the direct that would support a domestic violence. And I didn't need to. I didn't have to. Matter of fact, when it started going into it, I stopped it because it's not relevant for these proceedings. So it's going to follow too. So of course, going to bind over on all charges, find that the felonies enumerated in the complaint warrant and the misdemeanor did in fact occur in the city of Detroit. I would call them this charges and it should be filed over the Wayne County Circuit Court of Criminal Division for arraignment on the information, which will be May 31st at 9 o'clock.
Okay.
As to bonds, I believe that.
Oh, I'm sorry, May 24th.
Or,
Yes, you're right.
I believe bond is currently set at 35,010%. I think that may be excessive, given that I don't believe that there is any prior felony convictions, as indicated by the fact that there is no official information filed. We would ask that the court would, and of course, hearing the testimony of the complainant, it appears he is residing at that location. With no objection to continuing the order of no contact, which would preclude her from actually returning to her own home. But we would ask that the court would consider a reduction of the bond so that she may be able to leave the Wayne County Jail and be in a better position to assist counsel.
Where is she going? I have no idea where your sister's house is.
I'm sorry, I can't hear you.
I can't remember her address, but she lived around.
Only thing I can give me some information. What I'm gonna do is I'll refer this for the issue. I maintain jurisdiction over this until the arraignment. If you want to get some information that would verify all this information that she just gave, then you can refile it with me, or you can refile it when you get across the street. But I gotta have some verifiable information.
Thank you.
Follow me there.
Yeah, you got any issue on that? The issue on that?
Yeah.
Thank you. Yeah, we're going now.
Who has the bar? What case you
Hey.
I'm Lori.
Oh.
Yes.
Yes. She stood in for.
So you, okay. Stand by Nelson.
Nelson stood in for me. We're switching around.
So she's on the case like Nelson. What's your client? Anderson is, she's a girl. Nelson stood up.
Oh, so Nelson wasn't.
Me, I was out on,
So what is, your P number?
85191.
No client. All right. All right, ready? Calling case number 2356743, the people of the state of Michigan versus Ulysses Dubar. Defendant is charged with count 1, malicious destruction of personal property, $1,000 or more, but less than $20,000. Habitual offender, forced notice. Also calling case number 2256025, the people of the state of Michigan versus Ulysses Dubar. Defendant is charged with count 1, burglar's tools possession. Count 2, larceny from a motor vehicle. These matters are scheduled for examination. Defendant has failed to appear.
Philip Henderson for the people, P86029.
Hey, good morning, Your Honor. Neighborhood Defender Service by Lauren Anderson, P85191, on behalf of Mr. Jobber, who is not present.
Any contact?
Judge, I have reached out to him. I don't have any representations to make as to why he's not here this morning.
Well, that's for KP.
KP shall enter on each of these cases. Any bonds previously, set will be forfeited. Any bonds set, 30,000 cash. in each case.
Yes, Your Honor. He is on tether. I'm sure I will be able to hopefully locate him. I will reach out to the court if I can.
All right.
Thank you.
Well, you have to come in. I don't do those on Zoom.
I totally understood, Judge. I'll bring him in. Thank you. Have a good day. You too.
Oh, he assigned it. Right. You gotta give me the case. Well, she's from defense office, right? Cool.
I thought it was the same.
Okay.
Party's ready on Brian King. Calling case number 2355975, the people of the state of Michigan versus Brian King. Defendant is charged with count 1, weapons carrying concealed. This matter is scheduled for examination.
Good morning, Your Honor. Adam Woodruff appearing on behalf of the people, P86266.
And good morning, Your Honor. Lee Young, P44626, appearing on behalf of Mr. Brian King, who is present, standing to my right. Your Honor, he apologizes. He had a dental appointment earlier and it ran a little bit over, so that's why he's a little late. Sorry about that.
His case was set for 11 o'clock. It's 11:20. How about the case issue? I don't care what time. Your case is 11 o'clock. You need to be here before 11 o'clock. You understand? Because normally I don't wait at all. How the case be at 11:01? You can't get, you got a criminal case. A 5-year criminal case. You understand that? You gotta do 5 years, I want to get your teeth cleaned. That was rhetorical. I wasn't expecting that. But you get my gist. Say yes?
Yes.
All right. Let's go.
Brian King.
Thank you.
Thank you, Your Honor.
Yes, Your Honor, people are ready to proceed. Before I call my first witness, I just ask for a mutual order of sequestration of all witnesses.
Defense has no witnesses in court, Your Honor. No objection.
You know, witnesses testifying today at trial, anytime in the future must leave the courtroom, Zoom, and on YouTube, or be denied their future testimony. Call your first witness.
Thank you, Judge. The people would call Police Officer Lydia AR.
Sorry, Judge.
Do that.
Starting to be a habit, huh?
All right. I'm sad, what you think? My docket. I asked for it.
Big things here. I didn't think this was gonna hold. Yes. Your name.
Officer A, I'm sorry, Lydia, your first name, Liuya, last name is Ayar.
Thank you.
You swear by that firm, so truth, no truth, and nothing but the truth.
Yes.
Put a door for you. Have a seat. Proceed.
Thank you, Judge. Officer, could you please state your name for the record one more time?
Lydia Ayar,
And Miss Police Officer AR, where are you currently employed?
for the city of Detroit,
In what capacity?
as a police officer,
How long have you been with a police officer with the city of Detroit?
a little over 5 years.
You work with DPD, is it?
Yes, Detroit Police Department.
So I want to take you back to the location of Harper Ave and Woodhall Street on March 14, 2023. Let me rephrase the question, I apologize. On March 14, 2023, were you in the area of Harper Ave and Woodhall Street?
Yes,
Is that in the city of Detroit, County of Wayne?
yes,
Were you working at that location on that date?
yes.
Were you working alone or with a partner?
No, I had partners.
Multiple partners?
I had 2 partners,
What were their names?
Police Officer Mitchell and Police Officer Burks.
Were you in uniform at the time?
Yes,
What kind of uniform?
it was a black shirt similar to this one with a black vest over it with police, my badge and my name and badge number, and green pants.
Were the 3 of you on foot or were you in a squad car?
We were in a vehicle.
Was the vehicle marked?
Yes,
All right, so I'm gonna direct your attention back to that location on that date. Did you see anything that stood out to you at that location on that?
yes, I observed a black Chrysler 200 with the driver window to be tinted.
And were you in the driver's seat of your squad car at the time, or were you sitting somewhere else?
I was in the front passenger seat of my vehicle.
Who was driving the vehicle?
Officer Mitchell.
So you said you observed a vehicle with tints.
Yes, I observed the driver window to be tinted.
What's the issue with the driver window being tinted?
In the city of Detroit, in order for the front driver or front passenger window to be tinted, only the top 4 inches of the window can be tinted in order for it to be legal. In this case, I observed the entire driver window to be tinted, which is illegal. It's a civil infraction.
So it's a ticketable offense in this case?
Yes.
So what do you do when you observe this car window?
I, upon being able to read the license plate, I ran a lean check on the vehicle.
Okay, and so what happens next?
A traffic stop was initiated.
And what happens after the traffic stop is initiated?
I exit the front passenger seat of my scout car and approach the front passenger door of the black Chrysler 200.
And when you make it to the front passenger door, where are your partners at this time? If you know.
Officer Mitchell was on the driver's side of the vehicle. I can't recall where Officer Burks was at that time.
So you get to the front passenger side of the vehicle. What do you do when you make it to the front passenger side of the vehicle?
So the front passenger window was rolled down by the time I had gotten to the vehicle, and I observed a black firearm in plain view inside of the car.
Where inside of the car did you see this fire?
It was in an open storage space underneath the radio.
Would that be just right in the center of the vehicle then?
Yeah, like the front center.
So
Oh,
what,
not necessarily center, just like the front of the vehicle.
what do you do when you observe this handgun in plain view?
I immediately advised my partners that I observed a firearm. I notified them of this through code words.
How many occupants does this vehicle have?
Only one, the driver was the lone occupant.
Did you look at the driver at the time?
Yes, I did.
Do you see the driver of that vehicle in the courtroom here today?
Yes, I did.
Could you please point to him and identify him by an article of clothing?
Yes, he is seated there. He's wearing a black collared shirt.
Thank you. Your Honor, may the record reflect that the witness identified the defendant. Thank you. I just want to make sure I heard you right earlier. You said you notified your partner of what you observed. Is that correct?
Yes.
Do you hear Mr. King say anything at this time?
Yes, I heard him advise my partner, Officer Mitchell, that he did not possess a CPL.
What happened after you heard Mr. King advise your partner?
Officer Mitchell and Officer Burks, I observed them begin to escort the driver out of the vehicle, which time I maintained my position so that I could maintain the visual on the firearm.
What, if anything, happens next?
While he's being escorted, it took a little bit longer than usual to have him escorted out of the vehicle because there is an issue with his seatbelt. So in order to alleviate any safety issues, I recovered the firearm.
What kind of firearm did you recover?
It was a Glock handgun.
And where did you recover it from?
From that area that I mentioned, the storage space under the radio.
What, if anything, happens next?
I proceeded to make the handgun safe. It was loaded. There was ammunition in the magazine. There also was a round in the chamber. And I returned to my vehicle and conducted a lean check.
So
Okay.
what did you conduct a lean check on?
I conducted a lean check to verify that the driver did not possess a CPL, which he didn't. He also is not even of legal age to possess a CPL. And I also ran a lean check on the firearm, which was stolen out of Roseville.
Did the lean search you did on Mr. King, did it tell you his age?
It tells me his date of birth.
So how old is Mr. King?
He was 19 at that time.
I have no further questions.
Good morning, Officer Ayer.
Yes, ma'am. Good morning.
Excuse me. So are you and the two individuals that was in the patrol car in the special unit? Were you working a special unit that day?
We're assigned to special operations.
Okay. And what does that consist of?
What's the relevance?
As to their behavior that day, Your Honor?
What's relevant? They could have been in vice, they could have been in narco. I mean, you did traffic stop. Doesn't matter what the normal unit is. How is it relevant?
I will move on, Your Honor.
Thank you.
So the reason why this 2000 Chrysler was pulled over was because of alleged tinted front windows?
I observed the driver window to be illegally tinted.
Are you claiming that the front passenger window was also tinted?
I could not see the front passenger window. I only was able to observe the driver window.
Weren't you standing in front of the front passenger window?
As I stated, the window was rolled down by the time I had approached the vehicle.
Isn't it true that the window was only down maybe about, and holding up my hand, about 3 inches?
I can't recall how many inches it was lower there.
Okay, let me ask you this. You would agree that the dash cam in the vehicle that you were in was activated at the time the vehicle was pulled over, correct?
It should have been, ma'am, yes.
And your body worn camera and that of your partners was also activated at the time the vehicle was pulled over, and you all had contact with my client, correct?
Yes, ma'am.
Okay, and you looked at those videos?
No, I have not reviewed those.
But you know you are under oath to tell the truth, correct?
Yes, ma'am.
Other than this alleged front tinted windows, there was no other violation that you observed as to why you stopped his car, correct?
No, ma'am, the tinted window was the only reason it was pulled over.
Okay. And isn't it true that it was Officer Mitchell who actually opened up the driver's side door and went into the vehicle, reached into the vehicle before my client was removed and before you did anything inside the vehicle? You remember that?
They were attempting to take his seatbelt off, as I said, there was an issue.
Before the seatbelt issue.
What do you, I don't understand what you're asking.
Did you see Officer Mitchell open up the door and reach inside towards the console before the seatbelt issue was addressed and before you allegedly went in and retrieved an alleged handgun?
Officer Mitchell did reach into the vehicle before I recovered the firearm, ma'am, as I stated.
What was he reaching into the vehicle for, do you know?
To take his seatbelt off, ma'am.
It was, I'm talking about before the seatbelt issue.
I don't recall, I'd have to review the body cam.
I see, okay. I'm assuming that before my client was stopped, you did activate your vehicle's lights and sirens, correct? To get his attention to pull over?
The vehicle lights were activated, I can't recall if the sirens were activated.
Okay. So, question is, he would have known that the police were behind him and he was going to be required to pull over, is that correct?
Yes, ma'am.
And is your testimony that he allegedly left a handgun in plain view from a passenger side window? That's your testimony?
I observed a firearm in plain view from my position, yes, ma'am.
Nice. Now, it was after Officer Mitchell reached in that you then reached into the vehicle and allegedly recovered a handgun, is that correct?
Ma'am, I can't testify to Officer Mitchell's actions, but I can advise that I did recover the firearm.
You were isn't it your duty to pay attention to what your partner is doing?
It's my duty to make sure that I'm safe. I was maintaining.
As well as his duty to make sure you're safe, correct?
Correct.
Okay, and you didn't observe his behavior before you?
Ma'am, I'm confused as to what you're talking about. I already had stated that Officer Mitchell had reached into the vehicle after I advised him that I observed the firearm to attempt to take the seatbelt off of the defendant.
Not talking about the seatbelt.
Okay, then can you please tell me what you're talking about?
Based on the video I saw, he goes up, opens.
Objection, Your Honor, that's,
Objection
she's
sustained.
testifying at this point.
Okay.
Correct.
So to your recollection, you did not see Officer Mitchell open up the driver's side door and reach in
I would object to ask that.
towards the console.
This was asked multiple times and it was answered by Officer Neal.
It was asked one time, but there's been some confusion about it. I'm gonna allow it. You understand the question?
Can you repeat your question, ma'am?
Do you recall seeing Officer Mitchell opened up the driver's side door and reached into the console before there was any discussion about a seatbelt.
Reach into the console, ma'am,
Reach towards the console.
where the seatbelt button is, yes, ma'am, he did. That's where, to take the
Ma'am, that's not
seatbelt.
the question. I
I'm-
need you to listen to the question and answer the question. Most of them are yes or no. So repeat your question, please.
Do you agree that Officer Mitchell reached in towards the console before an issue arose regarding the seatbelt?
Did you see that?
Yes.
Now, with respect to this alleged violation, I know that you agree that Detroit adopted the Michigan Vehicle Code, correct?
Yes.
Okay, so what ordinance violation do you claim my client committed that justified you pulling his car over?
I observed the front driver window to be tinted greater than 4 inches from the top.
What ordinance violation is that? What's the name, what's the number
Asking
of
a
the
legal
ordinance?
question?
I'm sorry?
Asking a legal question?
She issued the
She
citation,
did.
Your Honor, she should know it. There is, for the record, I could not find an ordinance code number for that.
If you couldn't find it, doesn't mean there's not one.
That's true, so that's why I'm questioning her, but if you're not allowing me to find out why he was stopped, on
Do
what
I
law?
expect her to know the exact ordinance? She may know, or do you know the ordinance?
Not the number, not the actual MCL number, I only know the description.
So it is an MCL number?
There is, yes, ma'am.
Okay. Would it be MCL 257.709?
I couldn't tell you, ma'am, I don't know it.
It deals with windshields and windows though, the one you're referring to, correct?
Ma'am, the one I'm referring to is described as tinted windows greater than 4 inches from the top.
Okay, I'm not. Almost done, Your Honor. And just to clarify, you're claiming that from the passenger side window, which I believe you allegedly claimed was also tinted, the front window?
No, she didn't say that. She
Okay,
said the
So
window,
the-
the passenger side window was down when she approached.
okay. And through that window, you were able to allegedly see a gun in plain view, is that correct?
Through the open part of the window, ma'am, when I observed the firearm, I wasn't looking through the window, I was looking through nothing, just into the vehicle.
I'm sorry, I didn't understand your answer.
When I observed the firearm, I wasn't looking at it through the window, I was looking at it through the void from where the window was rolled down, and that was where I observed the firearm.
Okay, well, then through the partially open window, you claim you observed a handgun laying in plain view, is that correct?
Yes, that's correct.
Okay. I have nothing further to this witness, Your Honor, thank you.
Briefly, Your Honor, excuse me. Officer AR, you said the window, when you approached it, was rolled down. How far down was that window?
I can't recall exactly how far down, but it was rolled down enough so that I could see clearly into the vehicle.
So it wasn't closed, I'm assuming,
No, it was not closed.
and it wasn't all the way open to the door, is that correct? Somewhere between there.
Somewhere between, yes.
No further questions, Your Honor.
You can recross?
No, Your Honor,
Thank you.
thank you.
I have no other witnesses, Your Honor, the people would rest.
Didn't see any witnesses?
No witnesses for the defense, Your Honor.
Yeah, for sure. The people will move for a bind over on count one here, it's okay. Officers observed, tinted windows, ticketable offense, they make the traffic stop as she sees a gun in plain view. She hears Mr. King say to her partner, I do not have a CPL. She recovers that firearm, it's loaded, and she does subsequent lean search to see that he's in fact 19 years old. In the state of Michigan, the 21 years old is how it needs to be to actually possess a CPL. So, Your Honor, I believe people have met their burden in this case and would again ask for.
Your Honor, there's a question of fact as to whether there was probable cause to stop this vehicle, but I will raise that issue over in the circuit court at this point.
Right. We're having heard the testimony and arguments finds as follows. And on March 14, 2023, at Harbor and Woodall Street in the city of Detroit, Officer Lydia A.R. was on patrol in a modified uniform, marked vehicle, observed a Chrysler with tinted windows. The entire driver's window was tinted. Ran a lean check on the vehicle, did a traffic stop with the tinted windows, she approached the front passenger door. Front passenger window was partially down. She observed through the space where the window was down, in an open store space under the radio, a handgun, a firearm. Excuse me, in an open store space under the radio on the dashboard, a firearm. Defendant was the lone occupant of the vehicle, the driver. And then she heard the defendant say that he did not have a CPL. Also, that when she did a lean check, found out his age, he was not old enough to have a CPL. She recovered the firearm, which was a Glock. It's safe. It was loaded with one in the chamber. Or find that the felony enumerated complaint warrant did in fact occur in the city of Detroit. Probable cause exists to charge the defendant to be bound over Wayne County Circuit Court Criminal Division for arraignment on the information, which will be May 31st at 9 o'clock.
Thank you, Your Honor.
Thank you.
And first, real quick. On Friday, all we had was PCC. You okay? You okay if I just zoom in, or would you like a press?
Here it is, right here. You're the prosecutor, right?
Yes, for roughly.
Right. What's your name, sir?
Oh, yeah. Thanks, Judge. It's Ryan. R-Y-A-N. Last name is L-E. Nice to see you now. W-S-A.
Can you repeat the
7. No. 1, not 3, 11. No. Oh, did you hear?
7313.
2.
Well, telling my area. Thank you, thank you.
I don't know, I know.
Yeah, I know Mr. Cripps is here.
Mr. Brown's in the hall.
Brown's here too. So
Oh, okay.
I don't know if his.
Mr. Brown's client is not here yet, John. If he says, give me 1 minute.
Oh, that's fine.
He's on his way in. He's on the phone. He said he was on his way in.
1 minute.
I got you.
Can I see you tomorrow?
All right, take care, guys.
I remember.
Yeah. It's been a while.
Yeah.
Well, I'm gonna ask to put it in under 766. That's not a part of it. It's a preliminary.
I can't speak. I don't think they're. Next year is a whole.
Field testing 26. Well, I'll probably test it. All right, how are you?
Morning, Judge. Good morning. No worries. My client's not here. Yeah. I just talked to Phil Reagan and got a number that I wasn't able to get earlier, but and actually I went by his house, there's nobody there. So I have no explanation for his failure. All right. Put it on the record. Thank you. Yeah.
That's for Anthony Ruff.
Yeah. I just called both of them and put it on. There was some.
Okay.
It's Mr. Beasley.
No, I'm Rush.
Oh. Oh.
All right, parties ready? Calling case number 2356668, the people of the state of Michigan versus Anthony Ruff. Defendant number 1 is charged with count 1, motor vehicles operating a chop shop. Count 2, breaking and entering a building with intent. Count 3, controlled substance, possession, cocaine, heroin, or another narcotic less than 25 grams. Strike count 3 for defendant number 1. The people of the state of Michigan versus Timothy Beasley Jr., defendant number 2 is charged with count 1, motor vehicles operating a chop shop. Count 2, breaking and entering a building with intent. Count 3, controlled substances, possession, cocaine, heroin, or another narcotic less than 25 grams. Matter scheduled for examination. Defendant number 2 has failed to appear.
Good morning, Your Honor. Ryan Pesky for the.
I'm sorry. Defendant number 1.
Defendant number 1, Mr. Ruff.
Yes.
Oh, okay. It's like Beasley Ruff.
Upside down.
Oh, I'll just repeat. Ryan Mutesky for the people, P7313.
Good morning, Your Honor. Please court. My name is Mark Brown. My P number is 39562. I appear on behalf of Mr. Ruff, who's not present. I have no explanation for his failure to appear. I will make efforts to bring him as soon as I can.
Yes, Mr. Ruff.
Oh, Your Honor, due to his non-appearance, the people move that a KP bench warrant be issued.
KP shall enter any bond previously submitted shall be forfeited. New bond set 30,000 cash. All right, thank you.
Thank you very much, Judge. Appreciate it.
And Your Honor, with regard to.
Well, let's get the other appearances on.
Good morning, Your Honor. David Cripps, P34972, appearing on behalf of my client, Timothy William Beasley Jr., who's here in court. Tell the judge your name, please.
Defendant Timothy William Beasley Jr.
Thank you, sir.
Defense is ready to make a motion to sequester witness.
Your Honor, the people would join in that sequestration order, but ask for an exception for the officer in charge, Heather Fitzpatrick, who is out in the hallway, and I'd like to get her to assist me during the day.
Is she testifying?
Yes, sir.
I don't know whether, I mean, after she testifies, generally don't have an issue with it. Do you, Mr. Kraft?
I agree with that, Your Honor.
All right. So after she testifies, she.
I understand.
All right, but any and all witnesses testifying today at trial or any time in the future must be the courtroom, Zoom, and or YouTube, or be denied that future testimony. That includes the officer in charge. She may remain in the courtroom after she testifies.
Your Honor, there's a preliminary matter I'd like to address. I did try to resolve it before the exam started. I have a laboratory service report from the Detroit Police Department by Sergeant Spencer of the narcotics unit. Your Honor, I would be seeking to put that, to admit that into evidence under MCL 766.11B, which states a report of the results of a properly performed drug analysis field testing to establish that the substance tested is a controlled substance. Your Honor, that's exactly what I have, a field test. I'd like it to be marked as People's One and admitted under that list.
Any argument?
Yes, Your Honor, we object to that. I don't agree with these. I think they're inaccurate half the time. And what I've been provided is a form that says request for laboratory service. I don't see that as a field test report. So I would object to its submission.
And I would just add, halfway down, it says preliminary analysis, and it's marked chemical and true narc.
I'm saying what it is, you know, the issue though, is that the law changed. You know, it used to be that it would just allow you to admit it. Now, they changed the law to say that just read it, but the test has to be correctly performed. Language of that matter. So, or in order for the court to know that it is correctly performed, I either have to have someone here, the person who performed the true narc test, to say that they were duly qualified, that they followed all the steps that they were supposed to, follow, and that they performed it correctly. Or I gotta have another officer who witnessed it that is also duly qualified to perform the test, that they saw the person do it and did all the steps, and that they can testify that it was correctly performed. I gotta have that. Without it, no.
And I just want to advise the court, I do have a copy of the statute. I don't see the clause that.
You just read it. Read it again. And I'll stop you when you get to it.
Okay, I'll start from the beginning. The rules of evidence apply at the preliminary examination, except that the following are not excluded by the rule.
Excuse me, slow down.
Can I slow down a little bit?
Slow down a little bit.
Yeah, she's trying to keep up with
Slow
you. You're
down.
talking fast.
Oh, no, I understand. Should I start over?
Yes, please.
Okay.
Thank you.
The rules of evidence apply at the preliminary examination, except that the following are not excluded by the rule against hearsay and shall be admissible at the preliminary examination without requiring the testimony of the author of the report, keeper of the records, or any additional foundation or authentication. A report of the results of properly performed drug analysis field testing to establish that
Right there.
the
Properly performed. I cannot get that from a document. I can only get that through testimony. That's the part I gotta have.
I understand, Your Honor. I sent a subpoena to Sergeant Spencer. He asked me what this was about. I have a phone number for him, and I told him he was on call today. So I'm gonna have to call him maybe out of order, maybe last. And if I could be allowed to make a phone call out in the hallway,
Sure.
I would appreciate that. I didn't foresee that coming. Thank you, Your Honor.
Right. Sure, that's no problem. You call.
Thank you, Your Honor. I believe that's all the preliminary, matters I have, unless defense counsel has.
No, I already made my motion.
Okay, Your Honor, the people will call a Officer Brooks, and I'll go out in the hallway. Thank you. I just want to tell you what's. Sorry for the delay, Your Honor. I was having the officer in charge call Sergeant Spencer. No problem.
Save the rules. XA, these are Victor, IER. Last name Brooks, BROOKS.
Do you swear or affirm so the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, pull the door towards you, you have a seat, please. Okay.
Thank you. Please state your name for the record.
Xavier Brooks.
And, Mr. Brooks, what do you do for a living?
I'm a police officer with the Detroit Police Department, 11th Precinct.
And were you so employed back on April 28th of 2023?
Yes,
And were you on duty on April 28th, 2023?
yes,
And did your duty take you to 17801 in that area, 17801 McDougal Street, excuse me, and that's McDougal in the city of Detroit, county of Wayne, state of Michigan.
yes.
And when you were in that area, were you alone or were you with other police officers?
I was with other police officers.
If you recall, do you recall the names of those police officers you were with?
Yes, I was with Police Officer Edwards, as well as Police Officer Swart in my vehicle. There was also another vehicle nearby with us as well.
And do you recall the reason you were at or near that address?
Yes, there was a police run given to us by dispatch to me and my partners, as well as the other vehicle.
Okay, I'm not gonna take it, just you got a police run.
Yes.
Right.
You can't talk with some other vehicle guy. I mean, unless he's in two places at one time.
Oh, okay.
Okay.
Were you, when you went to that address, were you looking for a specific part or area of that address based on what the information you were relayed from dispatch? Did you go to a certain area, or was your attention focused in?
Yes, to the garage at the location.
Okay. And when you approached this garage at that address, did you hear any noises, see any lights? Can you describe, well, excuse me, strike that, let me back up. Approximately, if you recall, what time was this, day, night?
This is nighttime.
Okay. And what was the lighting like outside?
It was dark. There was about one street light in the area, so they provide some light.
And as you approached this garage, was there still some light from the street light, or was it obscured?
There was some light from the street light.
And were there lights on the outside of this garage, or?
No.
Can you describe what your senses were, what you saw, what you heard when you approached it?
Seeing the garage that had two doors in the front. The left door was cracked a little bit. It was dark inside. And as I approached, I did hear noises from inside the garage.
I'm sorry, you said you did hear noises from inside, or you did? I couldn't hear you.
I did.
You did?
Yes.
And what sort of noises did you?
It appeared to me like a tool that hit the floor.
Objection, speculation.
I wasn't even quite sure what you said. You said it appeared to be what?
It sounded as if a tool hit the ground, some sort of metal object.
Objection to the reference as a tool.
And Your Honor, witness can testify to his observations and reasonable inferences therefrom. I think that falls under that. I could flush it out as the court wishes, but I believe it's proper testimony.
Well, I don't know about reasonable inferences therefrom. No, I don't know about that part. He testified what he saw, what he heard. He said he heard something metal drop to the floor. Okay, I got that part. But you know what it is, I'm not gonna allow him to speculate on unless he could see it. Right, go ahead.
What happens next?
Police officer Callan was also there. He called out through, I'm not sure that was a door or window, but he called out through the right side of the garage. I was standing in front. We heard nothing, no response of any sort.
And what did you hear that officer call?
I don't recall exactly what he said.
At any point, do you hear any other officers identify themselves as police?
I don't recall anyone.
You're leading. This is adjusting facts, not an evidence.
Okay, thank you. I'll
rephrase, please.
Okay. What do you see in here after you heard this noise you described as a noise that sounded like something metal hitting the floor?
Like I said, I heard Officer Callan call out and heard no response after that. Then I myself from the front door called out inside. Didn't hear any response back to me. But I did hear movement inside the garage, so I did open the door.
And when you say movement, is that like footsteps or?
Objection as to leading, Your Honor.
Yeah, you are leading.
Okay, can you describe when you say you heard movement, what more sounds you heard more specifically?
I just heard movement.
Based on your observations, did it appear to you that people were inside the garage. Was that your conclusion?
Asking for speculation, Your Honor.
You're not asking for speculation. You have to
Your
lay a
Honor,
foundation.
I'm asking for what he thought at the time.
No, the question itself is leading, because you're suggesting an answer. You're suggesting that there's people inside. Moving inside a garage could be anything. Could be rats, could be a dog, could be a cat, could be, he just said movement. You know, so, but when you throw in there that it's a person, now you're suggesting an answer.
What happens next?
I opened the left side garage door. And then I enter onto the left side of the garage and I observed two black males. They were like crouched down at the driver's side wheel area and started to stand up. I asked them to show me their hands.
And you said there were two black males?
Yes.
Do you see any of those persons you just described in the courtroom today?
Yes.
Can you point to that person or persons and describe an article of clothing?
That they're wearing today?
Yes.
Gentleman in the black polo shirt.
And Your Honor, I'd like the record to reflect identification of defendant. What on my information is listed as defendant number 2, Mr. Timothy William Beasley Jr.
All right, court will so recognize that.
Okay. What happens next after you, did you say hands up, or I apologize, my memory's not good and I don't want to leave you, but what, can you please refresh my memory as to what you just said, what was going on when you entered?
Like I said, they were the driver's side front wheel area of the vehicle. I asked to see their hands. And after that, we kind of brought them out of the garage to detain them. That way we had more space.
Okay. At this point, are you the only police officer in the garage, or are there other officers in?
No, so my two partners were behind me, and there were Officer Cal and another officer on the right side of the garage as well.
After you ask them to come out, what happens next?
They both were detained and brought over to the scout car. I did run the vehicle that was in the garage and found that it was in fact stolen. And the other officers were with both males at that time.
Okay. And I'm just curious because some do and some don't. Do you have a copy of your report with you?
With me, no.
And Your Honor, I'm just asking for one moment. I wanted to make sure that I'm hitting everyone. Sure. Okay. After, again, Officer Brooks, can you just refresh me? Did you say Mr. Brooks and the other black male there? I'm sorry, Mr. Beasley and the other black male, were they detained?
Yes.
What happens?
Like I said, I did run the vehicle, lean, it wasn't, back stolen. And both, Mr. Beasley was with my partners, the other male was with the other officers that were there. And, they, at that point, they conducted a search incident to arrest, due to being arrested for, being with that stolen vehicle, having possession of it.
So you did not perform the search of Mr. Beasley?
No.
Were you dealing with Mr. Ruff or?
No, I was, at that time, I was focused on the vehicle, confirming that the vehicle was stolen.
Okay. And you mentioned that vehicle, how do you confirm the status of the vehicle?
Checked it through lean system, which is a law enforcement information network.
And what do you put into lean, just a make and model or something else?
The license plate, as well as the VIN number.
And did you look at the license plate and on the vehicle to get that information?
Yes.
Just generally, because I'm not sure it came out yet, what type of vehicle was that to the best of your recollection? Was it like a Chevy Corvette, or that's what I'm asking for, not suggesting an answer?
It's a Jeep Grand Cherokee.
Did it look to be new, old? Could you tell from just looking at it?
It looked to be a newer model.
And the condition of the vehicle, was it intact or in some other condition?
Answer.
I'm sorry?
You asked him about the condition of the vehicle, but when you start suggesting an answer, then you leave.
I'll rephrase your answer.
Whatever. I mean, you can ask him about the condition.
What's the condition of the vehicle?
The passenger side rear window, that was busted out. And the front of the car, the front bumper and the grill, were completely off of the car. They were actually, in the garage as well, but off of the car. The front, both front fenders or quarter panels, were also off of the vehicle. I don't recall exactly if the hood was off or up, but you can see the engine bay, inside the engine bay area.
I see. In the garage, did you see any,
Maybe suggesting an answer. Leaving.
well, and Your Honor, that was based on a previous question. I would consider that follow-up from his hearing, but I'll rephrase.
No, he said he heard what he thought was a metal object drop. That's what I got. You can't suggest what it is.
Officer Brooks, could you please tell me the items you took note of that were in the garage?
Just the parts from the vehicle that I seen that were off of the vehicle. There was like shelving the probably part of the garage, and then I did see bag. I'm not sure exactly what tools were in that bag, but there was a tool bag as well in the garage.
You said tool bag?
Yes.
And I apologize because my hearing's not great. I wanted to make sure. Did you say shelving?
Yes.
So there were like shelves?
Yes.
So shelves and a tool bag.
Yes.
And anything else you took note of you could see?
That's in the parts from the vehicle that were taken off.
Objection as to that speculation.
I'll take it that they were off.
Oh, yeah. This. You mentioned fenders and a grill. The fenders that you saw in the garage, were they the same color as the rest of the vehicle?
I don't believe he ever said fenders, John. I heard him say front quarter panels.
And I would dispute that. I wrote down fenders because that's what I.
Well, I didn't write down fenders either, but I'll go ahead and allow it.
Did you see fenders or what you referred to as front quarter panels? I think you said both words.
Yes, I said both.
Fenders or front quarter panels that you saw off the vehicle, were they the same paint color as the rest of the vehicle?
Yes.
So they matched?
Yes.
And the vehicle, did it have fenders on?
No.
Did it have its grill on?
No.
Did the grill appear to match the paint of the rest of the vehicle?
The grill was a different color, but it does match what I've seen that vehicle, type of grill that vehicle does have that I've seen previously.
Okay. And the grill that was off the vehicle, was there a grill in place on the vehicle in addition to that? Or?
No.
Did you yourself observe anything recovered from Mr. Beasley?
I did, yes.
Do you recall where from Mr. Beasley any items were recovered?
I do remember items being recovered from his pockets, as well as his waistband area.
You said you remember. You saw this or someone told you?
Well, I could tell you which pocket I've seen items come from him onto our vehicle.
Okay, you didn't quite answer the question. You already said that one of your partners was dealing with Mr. Beasley because you were dealing with the car.
Yes.
Right?
Yes.
Did you see Mr. Beasley being searched?
Yes.
Well, you were able to observe that?
Yeah, I was in our vehicle, he was in front of the vehicle.
All right, you go ahead.
Okay. Did you see, could you see specifically what the items were that were recovered from Mr. Beasley?
There was a plastic bag, and there was, that I observed, and I did observe a key fob as well.
Take those one at a time. Start with the key fob. You said this was a Jeep Grand Cherokee?
Yes.
Did the key fob say Jeep on it?
No.
Did the key fob say any vehicle make or model on it?
No.
Plastic bag you mentioned, was that an empty plastic bag or was there anything in that plastic bag?
During that time, I could not tell. I could just see plastic bag.
We've been through, I think, on the record that you observed Mr. Beasley be detained and searched. Do you know if Mr. Beasley was arrested?
Yes, it was.
And did you transport Mr. Beasley to the station, or were you involved in that at all? Or?
Yes.
Those items that were recovered from Mr. Beasley, did those go in? Were those also transported by your car, or?
Yes.
Did you have any role in tagging those or preserving those, or was that up to other officers?
That was up to other officers.
I don't have any further questions for officers.
1 minute, Your Honor. Sir, you said you went to 17801 McDougal?
Yes.
That was a private residence?
Yes.
And before you entered that property, did you with your own 2 eyes see a crime being committed?
No.
Did you have a search warrant to go into that garage?
No.
Did you have permission from the owner of the property to go into that garage?
At that time, I had no permission. The property manager did arrive there after we arrived.
Thank you for that. My question is, before you went into the garage, did you have permission from the property owner to go into the garage?
No.
Thank you. Nothing further.
You encountered someone who identified themselves as the property manager at the address?
Yes.
Did that property manager indicate he was representing the owner of the house and garage?
Objection, hearsay.
And
Hearsay.
Your Honor, it's 1101 subsection 8, at preliminary examinations and criminal cases, hearsay is admissible to prove with regard to property, ownership, authority to use, value, possession, and entry.
I would agree, but it would also have to happen before the police did whatever they did on that property, not after the fact. If you can show me a law that says that, the police can go into a private structure, resident property, do whatever they want to do, and then afterwards get permission or a warrant. How you
when there's a call to the police,
it doesn't matter. They got information, so they have the right to do a reasonable investigation. They still don't have the right to enter private property.
and Your Honor, this hearsay doesn't say anything with regard to time, and I believe, if I'm hearing, you're reading in a timing requirement, that would be for a suppression motion at circuit court. I'm just
I can
asking.
deal with that here. I can definitely deal with that here. That's part of my job. Is the weed out, the stuff that don't need to go across the street. And you can't, you gonna have to show me, counsel, where can any police officer enter onto private property without permission and without a warrant, and to conduct a criminal investigation.
And Your Honor, that's where I think I'm not getting, I am simply talking about testimony that Officer Brooks is going.
I'm talking about his whole testimony. Because right now I got that they went on this property, there was no crime being committed when they went there. There was no warrant, and they did not have permission.
And Your Honor, there's.
So that goes to everything they did while they were there, everything.
When you have testimony from a property owner that establishes the crime and the evidence of a call coming in.
You can't get it after the fact. You can't do your investigation and then say, oh, okay, you own this property, whatever they ask them, that property owner. I don't care, it doesn't matter. They have to have that beforehand, not afterwards.
You don't know that a murder's been committed until you see a dead body. So how can you prove any crime?
How can you what?
How can you prove any crime? There's a stolen car, there is a crime.
We have rules that they have to follow. Especially rules dealing with private property. They cannot go on private property without permission or a warrant. We don't have that here. We have no permission, we have no warrant. They went on private property anyway.
Yeah.
We don't even have reasonable suspicion.
Based on a
Let
call.
me finish. We don't even have reasonable suspicion here. They got it based on, I don't care about the call. The call took them there. It's what happens once they get there that's relevant to these proceedings. From the point they get there, that's what's relevant. When they get there, they have no permission, no warrant. Officer goes up, he hears something drop in this garage. Something metallic drop. And he hears some type of movement. That does not give you reasonable suspicion to enter that garage. That door is closed, it's dark, he can't see what's going on. He then opens the door, goes in and sees them. They're detained and they take it from there.
And there's other witnesses that we could.
I'm telling you what I got now. You can give me permission and a warrant prior to them going on that property, then we're good. But if you're gonna give me afterwards, this case is gone.
And Your Honor, I can't get you a warrant, but I can get you calls.
I don't care about calls. I don't care. Calls don't mean nothing. Calls, that's all hearsay anyway. That's why when we get to, whenever an officer gets up there and say, I got a run for, I said, I don't care what the run is for. You got some information. What did you do based on that information? That's what I tell them. Then they go on to what they did based on that information. Once they get to wherever they're going, they give me reasonable suspicion to go further, or they don't.
And Your Honor, if my neighbor sees someone breaking my window and climbing in, they call me, I call police.
Then the police go to the property, they go look, they see a window that's broken in. Now that may give them reasonable suspicion to go further. We don't have that here. Show me the reasonable suspicion to go further.
Okay, now.
Because that's what they have. That's what they have to do. I mean, if you can give that to me, if you can give it to this witness or some other witness, fine, we can go forward. But if you're telling me that the basic facts of this case are not going to change initially, then no, I'm throwing this case out.
And Your Honor, I obviously can't tell you exactly what other people are going to testify to without, but I think I could get other testimony.
Okay.
That would not give you a warrant, Your Honor, but reasonable suspicion.
Reasonable suspicion that a crime is being committed. Based on what they did after they got there. Not the information they received beforehand. I don't care about that. A police run that someone else said A, B, and C doesn't mean a thing. That just takes them to that location. That's just information. I got information, I acted on it. I went to that location. Now, once I get to the equation, that's what happens. That's when the real work starts. Now you gotta give me reasonable suspicion that the crime is being committed.
And Your Honor, in the scenario I'm talking about, and again, this is coming through reports, and I'm just trying to get the court's position on whether, I might make a motion to adjourn to get other people here, because I have officers with hearsay forms, but I don't think that would provide the detail that the court is looking for. As far as a 911 caller and a property manager. And I think, Your Honor, basically the scenario I'm describing is those people reporting things to the police.
I understand, but that.
And I would say it's fair to
I know
them.
what's calling, let's break it down. And because that's my job, that's what I'm supposed to do.
I understand, Your Honor.
That 911 caller gives the police the reason to go to that location. But it's still a private residence. Okay, now, to go on that residence, they have to show me reasonable suspicion that a crime is being committed. They have to be articulated.
And Your Honor.
And saying that I got information from A, B, and Z, I don't care about that. I don't care. That's hearsay. Nope, ain't enough.
This is my understanding, because you know how things can change between reports and testimony.
Yeah.
My understanding is not the property owner makes observations, relayed to the property owner. The property owner says, no one has permission.
Afterwards, though.
No, I'm saying before. These are calls coming into the police.
No.
As in
You're saying that the property owner gave the police permission to go on the property when they went on the property. That's what you're telling me. Because if you're saying that afterwards, no one had permission to be on the property, then no, that's not gonna fly.
My understanding is there was contact between this person who made the initial observations and the property ownership.
So double hearsay.
Yeah, but if I call them both.
Doesn't. Again.
And if the property.
That's only all that.
And if the property manager calls the police as well.
That's information given to the police that says maybe something here is going on that shouldn't be going on. That's all that is.
And
that's all it is. Which gives the police, as they take the right to go over it, I'm gonna go check it out to the best of my ability. So I'm gonna go over and look. Now they go over and look, the garage is dark. They don't see anybody on the premises. There are not vehicles and parts littered on the driveway, on the grounds, or anything like that. I got none of that, nothing. But they go on the property. They get up to the garage. This officer hears what he thought something dropping in the garage, metal dropping. And then he heard what he thought was moving. That's all we got. That is not reasonable suspicion of a crime. And you got to have that to take that next step, which is opening that door and going in.
And here's.
Which is, you're supposed to have reasonable suspicion before you even walk on that property.
Here's what I would say, Your Honor. Based on my reading of the reports. And the fact that the property owner was there before the people who were arrested were even taken off the premises. My understanding that
it doesn't matter.
The property owner says no one has permission. Please check it out. Even if they told a precinct, the dispatch, that's collective police knowledge, Your Honor, and I think that's permissible. And if you're saying even under that scenario, I'm going to
under that scenario, the police should be getting a warrant.
Your Honor, I believe there's.
They know why they were going there.
What I would call exigent circumstances, because if you wait to call a prosecutor and a judge, I think the people knowing that there's people outside the garage are gonna flee. And I think that's an unreasonable expectation of the police who are acting in real time, and especially if, and there's not that testimony on it, and I understand, if I could get a property manager here that says, yes, I got a call from Joe Blow, my neighbor, and I told him no one had permission, and then I called the police. I think that's the exact scenario that I laid out when I said my neighbor called me, someone's breaking into your window, and I call the police and say, yeah, police, please check out my house. I'm not there, I didn't give anyone permission.
Before they did it. Before the police stepped foot on that property.
I would have to get the call records of the property manager.
That's what you gotta give me before the police step on that property.
The reason I think this
If
is.
it's afterwards, no. I'm telling you, that law is, I know it.
The reason I think this is a reasonable scenario is because the property owner showed up before, well.
I don't care about that. He showed up after the fact. Those people were already detained, already in custody. So the police had already acted. No, hold on. Let me finish, because, the other part of your argument is that, they gotta wait, to go to the prosecutor's office. The same thing, if they had if they thought that Mr. Beasley had committed an offense, was in his house, what would the police, they'd sit outside until they got that warrant. If he walked out, they'd arrest him. When they got that warrant, then they go in and arrest him. But they get the warrant because it's private property. Now, again, you have to, and we can go back and forth all day long, but I'm telling you, what I have to have, I don't have right now. I have to have that the police had permission to go on this property before they went on it. That's the bottom line.
I do understand what the court is saying, and I have been listening, and I appreciate you explaining that to me. I do. The reason I think it's reasonable that I might be able to prove your scenario is because the property manager got to the premises before the transport of the people who were arrested even left. So that would at least suggest that there is communication between the police and the property manager.
No, it doesn't. It just says that someone told the property manager something and he went over there. I don't know if it was the police. I don't know if it was that neighbor that called in the first place. I don't know who it was. And you don't either. So.
And I need to get.
I'm just telling you what I need. You can put on as many witnesses as you need to put on, but I'm telling you what I gotta have. And I'm telling you, I don't have it now. That's the only thing I'm telling you. Okay?
I understand, and I want to be extremely candid with the court. I did send subpoenas for those people, but I termed it the name of the property manager or officer who can provide hearsay. I have today officer who could provide hearsay, but they don't have what the court's requiring as far as timing. So I'm just saying, if I put all my witnesses on today, I'm gonna need an additional date to get those officers here. If the court is not willing to do that, I don't wanna waste the court's time. If you understand what I'm saying.
Right.
And I think, can I tell you with 100% certainty that I can provide what the court's looking for right now? No. And if that gives the court a reason to make a ruling, I understand. But I'm just saying, I might be able to, but not today. And I would defer to the court, and obviously defense counsel can put in his wishes if you want me to continue with the witnesses I have today, or if you think it's gonna be a moot point, then I would ask for another date, or then a ruling based on my admission that I can't give you property manager timing testimony today. And I'm trying to be as honest as I can.
No, I appreciate it. No, I understand. Mr. Cribb?
Yes, Your Honor. I think this case should be dismissed today, and I read the police reports too, and I think what he's referring to is some hearsay discussion they had with the property manager after the incident occurred. after my client was in custody. That's the way I read the officer's report that I'm looking at.
And I think that gets into very specifics because if the property manager is in contact with other officers who aren't the officers on the scene,
But that's after the fact.
but that's collective police knowledge, Your Honor, because they can say, go check this out. We think there's a crime being committed, in real time.
They didn't talk to.
If I call the police and say my house is being broken into, the police, in my experience, don't say, hey, are you the leaseholder? Where's your lease? What's your deed? What's going on?
Oh, because they're assuming certain facts based on you saying my house was being broken into. So what you told me is that someone else called and said, there's something going on over here that I don't think should be going on. But I don't know what they said, but they gave them some information. All right.
Yeah, and my reading of the report
again,
says they're stripping a car.
Okay, even if they said that, they're over there stripping a car. All right. Now, the police get to go over there to that property and take a look. Not on the property. They can't go through the property. They can't go digging up the property. You know, they can go over there and just like any other citizen, walk down the street, take a look. Take a look. And based on what they see, based on what they see, they can then articulate reasonable suspicion that a crime is being committed. They have the ability to act on that. But I don't have that. I don't have that. I got them going there at night in the dark. It's dark. The garage is dark. Everything's dark. They can't see anything. I got nothing that there's anything in the yard. Got nothing that there's anything in the driveway. So at this point, there's no reasonable suspicion that a crime is being committed. So they go on the property anyway. They go on the property, get to the garage. Officer hears something falling, what he described as a metallic object falling. And then he described, he hears some movement. Metallic object falling and movement is not a crime, even though another officer said something, he didn't know what it was. He could have said, police, come out, whatever. They didn't. They didn't make any noise. They didn't respond to it. You still gotta show reasonable suspicion that a crime was being committed. They don't have it.
May I ask the court a question?
Yes.
Okay. If there's testimony that whatever, random person says, I see them stripping a car at this location, and you have the owner of that location saying, I'm not stripping a car, I didn't give anyone permission to be on the property. If those calls are coming into police during this police run, my view of the law is it's permissible for the police to take action.
No. To go onto that property, they have to have reasonable suspicion to act, to go onto the property. And now, I don't care and that's the police that are acting. They have to have the knowledge. Now, the owner of the property could have been calling Sergeant so-and-so because I know him and, I want to find out what's going on. I think something's going on in my property. I want you guys to check it out. And he's doing it at the time, even at the time they're going on the property. It doesn't matter. You can't transfer that knowledge. They have to have that knowledge.
Your Honor, and there is case law that says collective police knowledge is permissible, so
I think it's dealt with as the investigation and the act of the police are going on, not, that Sergeant so-and-so could have been in Miami vacationing when he got that call. I don't know. You have to be able to, show me that they had and not only that knowledge, and that call was made before they acted.
And I just think you're
not while they acted, not after they acted, not after they detained them, made before they acted, made before they stepped on their property.
And Your Honor, I don't know if that level of detail is in police dispatches. Check this property because the property manager called me at 11:47 and told me to. I just don't believe that level of detail is put in police dispatches. So I think the court is assuming in the negative when.
No, I'm not assuming anything. I'm just taking what you give me. You know, I don't read these reports. I don't read the investigative report. I don't read nothing before I do these exams because I don't want to have any information. The only information I want to have is what I get from right here, from the witnesses and the evidence, whatever, you know, that you enter. That's all I want.
If the property manager contacted the police at or near the time that the police are going to the location, just because he didn't speak to the exact officer who's going on the property, the information, and maybe not all the details, is relayed through dispatch. And I think there's case law that says collective police knowledge that.
I don't agree with that. And I wouldn't go along with it either way. We have certain constitutional rights that protect citizens. All right? And I'm gonna stand behind those before I stand behind anything else. You know, and I could be wrong. You know, I'm not perfect. I could be wrong. But, you know, to tell me that, or even suggest that you got a group of officers who are acting, and from the evidence I've heard given thus far, without reasonable suspicion that a crime was committed, and then you're saying that another officer or officers have additional information that would give these officers permission if they knew it, but they don't know it. The officer acts on what they do know, not what someone else knows.
Right, and I understand the court's ruling that he didn't want, that the court didn't want the contents of that dispatch. But I'm saying it's quite possible. The property manager calls the 11th precinct. The 11th precinct says, check this out, without giving the level of detail that the court is requiring. And I understand that I would have to get that property manager and say, did you call the police? What time did you call them? Did you tell them that it was okay to check out their property? And if he told an officer, even if it was the desk sergeant or whatever, just because that is all the details aren't related to a specific officer on the road, I don't think that converts it to a constitutional violation to suppress everything that happened thereafter. But that's my view of the law. And I think that's a reasonable view.
I don't. I think he's misstating the evidence.
And I'm not, I'm
Based
just,
on what I read in his
No,
own
I'm
police
not.
report.
I'm making an argument for continuance.
Argument.
Yeah.
But that's not what's in his own police reports. He didn't talk to the property manager until after my client was arrested. That's what it says right in a police officer's report I'm looking at here. So I don't want him to mislead the court and say that they talked to the property manager prior to going on that property, because they didn't. Unless the officer.
I know the property manager talked to the police. I don't know the time. That's what I'm saying.
Well, it says in Officer Swartz's report, it was after arrest.
Officer Swartz was one of the officers. He's not on the desk.
He's one of the officers that went out to the house.
Yeah.
I understand that. Okay. All right, this is what I'm gonna do. I'm sorry. Officer Brooks, you can step down. Thank you. I'm gonna continue the hearing. For the not sole purpose, but for the first purpose of that, of presenting a witness that can say that these officers had permission to enter that property prior to them entering that property. That's what I need.
And Your
Okay.
Honor,
And again, if it's him, like, for example, this occurred at night, it was dark. This is in April. So April 28th, yeah, 9, 10, whatever, I don't know what time. So if you bring in someone that says, that owns the property or that has control over the property, that says at 2 o'clock on the 28th or at 10 a.m. on the, well, it would have to be that date. It would, because any day prior, then I'm gonna say you should have got a warrant and it's still gonna be gone. But on that day at 10 o'clock in the morning or 3 o'clock in the afternoon or whatever time it was, that he contacted the police officers and had information that he believed a crime was being committed on his property. He wanted them to go over there and give them permission. We'll go with that. But again, it has to be before, not after. That's the way I see the law. That's, that's the way I see it in terms of protecting not only the rights of this property owner, but my rights as a Detroit property owner and everybody else's rights as property owners.
and I just want to ask a procedural question now. If I talk to the property manager and he says, I called on that date on such and such a time, I would go ahead with the next date and call him in to testify, and then I'd have to exactly establish, and I believe I can through the police recordation of when they're exactly arriving and stuff like that. So I think we can nail down the time. If it's anywhere, if it's close, I want to be able to call the property manager. If it's after, if the property manager says I didn't tell anyone they had permission until I got there or anything like that, I would like to contact the court and then cancel the next date because I don't want to waste the court's time. If that's okay with defense counsel in the court.
I don't know really what he's talking about because every time I keep reading the report that says they didn't talk to the property manager until after my client was arrested and placed in a police car.
And that's the officer that's on the scene.
Yeah, they gave you the reports of the officer on the scene. I don't know if he talked to some other officer which initiated the contact of that property and gave permission. That, that would be different. I don't know. Then we're talking about a person who either the property manager or the police officer that he talked to that would have to testify to that. There wouldn't be any, I couldn't see there being any record, so to speak, of it. So, yeah, that's what we're gonna do. All right, are the parties available? How much time do you think you'll need?
Would 2 weeks be too long, Your Honor?
Yeah, I don't think about 2 weeks.
Oh, okay. A week? Would a week be okay?
A week, I can do a week.
Okay.
Would this be a time for him to let us know?
No, this would
When
be,
we decide-
well, I'm gonna give them time for continued examination. This will be the time that we would have any further testimony. We would finish this exam up, so not only that information, but any other witness you got.
And Your Honor, I'm what I think reasonably protecting the case. If I find out that I can't do what the court is asking, maybe I could get Madam Clerk's email and I have Mr. Cripp's email and to contact the court beforehand.
Right, and then I'm just gonna dismiss based on what I've heard so far.
Thank you, Your Honor.
Yep. Mr. Krebs,
Yes, Your
you
Honor.
understand?
I understand totally.
We do, Wednesday the 24th. And, I'm open like that all morning.
And Your Honor, even a day before would be good. The 24th, I have a competency hearing in, Thursday.
I can do the 23rd also,
Okay.
Tuesday the 23rd, 10 o'clock, 10:30, 11:30.
Oh, that would be great, Your Honor.
Judge, I have an exam in front of Sheila Johnson in Southfield District Court at 9 o'clock. I don't know what time I'll be finishing.
And Your Honor, did you say that, I'm sorry, the 24th, it will-
I'm open all morning, 24th.
I'll make it work. I
Are
think
you
I can
open?
make it.
I can't do the 24th here.
Oh, okay.
So I'm in federal court at 11.
Okay. About 25th.
One is me, Judge. You wanna see the 26th?
No, I got 26th,
Oh.
25th, I'm not 26th. Not available, I'm not available.
Oh,
I'm not
that's
gonna be
right.
here. 25th, right, the 25th, available.
25th, I have a homicide exam in front of Judge King at 10 a.m. And at 2 o'clock, I'm in front of Judge Larry Williams on a continuing exam.
How about 9? Nine o'clock on the 25th.
I have 2 circuit court cases that I'm supposed to be in court on at 9 o'clock before my exam in front of Judge King.
It is at 10.
Yes,
You know how long it's gonna be, you got an idea?
I think that's a lengthy exam.
The 22nd, is anyone available the 22nd? It's a Monday, but I think it's enough time for me to make the calls.
Yeah, last one is 11.
11 o'clock. Yeah, do anything after probably 11:15 starting Monday.
Okay.
$11:15, Your Honor?
Yep.
Okay, 5:22. May I approach?
So the 22nd?
The 22nd, 11:15.
Yeah.
No, it's fine.
Oh.
Oh, yeah, I got it. Thank you, Judge.
Can I get a manager to refer me to contact if I can't get things together?
Okay. Just gonna write it.
Oh, that's fine.
Timothy, I'll talk to you in a moment.
Sorry.
That's okay. Thank you so much. Yep.
Oh, here, you get this to,